Oh, and I actually just stopped recording them when I should have said something else. It says here, right, they're trying to make out that it is probable that they had a fairly simple conception of an assembly where debates were followed by resolutions or bills. What a load of tosh. It says causes, like political causes. And what is a petition campaign is a political cause, and that's got its own clause as well. So this is tosh. These people are actually charlatans. And actually, I can tell you the actual real wording of it, illegal prosecutions in the Court of King's Bench. And it says Court of King's Bench for matters cognisable only in Parliament. So there's a book called Elsinge, which is really important. Or the book's not called Elsinge. The person who wrote it's called Elsinge, right? And it's actually got to do with the Star Chamber, right? Because the Star Chamber was part of Parliament, okay? And the King could have it when he wanted. So you've actually got the Star Chamber, which is a court, one of the King's courts that he could end the Court of Commission, but they abolished those courts. But then they had Westminster as well, which was one of, you see, Westminster Hall, the Court of King's Bench, was one of the courts, right? Because the Court of King's Bench, which they held in Westminster Hall, was one of the courts, like the Star Chamber and the High Court of Commission, okay? And you see Westminster Hall's in Parliament, right? So these are King's Bench courts which are in or associated with Parliament, right? And then you've got like the circuits that go around England with the King's Justices. They're the King's Justices, but the King's presence is always supposedly meant to be in the courts, right? But then you've got like these petty sessions in the local areas where you have a magistrate, right? For less serious crimes. But it's still all meant to be, the King's law, right? The King's courts. Now, when you've got this Article 9, which is illegal by prosecutions in the Court of King's Bench for matters and causes recognisable only in Parliament, right? Now, the thing is, when Parliament could actually prosecute people, either House, the Lords or the Commons, but the process for impeachment in the Commons was to have a vote on it, and then the Speaker would go and to the bar of the Lords and hand in the impeachment thing, right? So the people could be questioned at the bar of the House of Commons. They could answer questions because you have proceedings in there, and the House of Commons could make resolutions and orders and bills and put them through like judgments, basically, but they had to go through the House of Lords, didn't they, to get royal assent, remember? So it's still going through to the House of Lords. But from the proceedings that I've seen in the House of Lords journals, they had like that Biggs's case, which I think if you look for between 1847 and 1837 and 1840, and also Harlow versus Baker, right? And you can see them because they had to kneel at the bar. They made them kneel at the bar. And I've got that proceedings on my webpage, on the Facebook page, right? So it seems like the impeachments or the proceedings, legal ones, were heard in the Lords, but this is to do with Gordon Brown mashing up the whole constitution with the Supreme Court. You need that in Parliament for it to function, because otherwise all your right to petition and all these type of things can't really work properly and things like that. And you see when they got the Ombudsman, you see MPs sign off complaints about government departments, so the Ombudsman deals with them, but the Ombudsman can't deal with complaints about MPs. So who deals with that? Well, they're meant to be dealt with in Parliament. That's why we've got impeachment, right, by petition. But the petitions are blocking and obstructing it, right? Yet we're meant to have the MPs are meant to be democratically accountable to the public, right? They are meant to be democratically accountable to us. but they don't want to be. In fact, they've made them more accountable to the police. They're meant to be more accountable to us than they are the police, because you don't need the police. If we've got evidence on them and we submit it in, then, we've done the police work, right? Because the police aren't meant to be able to prosecute them for things that are being done in Parliament. It's meant to be only done by impeachment, right? But then you've got that in Erskine May, it's saying that misdemeanors are not accountable by the King. They were saying that, I think I'm talking about the 1640 short Parliament, and this is before the Bill of Rights, the article in the Bill of Rights, where John Pym is saying that, the King's courts, which is effectively like the King's bench, right, can prosecute out of Parliament for things done in Parliament for like treason, felony, and breach of the peace, but not for misdemeanors, not for minor cases, because they're privileged. But then when you've got these Parliamentary Privileges Acts, it's like they say that they can be prosecuted like after the Parliaments or in between the sessions and things like that, or they can start proceedings, but they're not liable to be arrested and so forth. And that's the evidence that needs to be included. But after 1688, we get this clause, right? And it's more what the illegal prosecutions clause is more related to. It's more to do with like when they had the Star Chamber and the Court of Royal Commissions and the King's Bench in Westminster Hall, right? And the fact that if there was to be any prosecutions of privileged persons or any prosecutions what concerned matters that were being brought to Parliament, like in the Harlow Baker case or Biggs, I think there was a bit of a tumultuous assembly outside Parliament or in the doors of it, and one of the magistrate, they had a magistrate knocking around, and apparently Parliament told them to do this or that or something, right? And they were up for disturbing the peace outside Parliament or coming into Parliament or something like that. And it's to do with the fact that for matters cognisable only in Parliament, if the House vote on impeaching someone and then the Speaker goes to the Lords Bar with the notice, then it was decided in Parliament, right? So then you can have a trial in Westminster Hall at the King's Bench because it was decided by Parliament. Do you get me? Right? Whereas they'd only do that if it was either privileged or if it was a cause which was under the jurisdiction of Parliament, like petition cases, right? Because they're not allowed to be prosecuted in the courts. And if they are, you might claim your privilege, right? Because, for causes that are meant to be decided by Parliament. And that's the difference. And that is actually what it's all about. So the King's Bench, which was in Westminster Hall, was also hearing cases from all around the country as well, like Court of Common Pleas and so forth, where people might have trespass cases. There was that George Cook, the Sheriff of Yorkshire, writ out a privilege for Westminster Hall in a trespass case, right? And that was a matter heard in Westminster Hall, but from a local area, just a normal case. That could be heard in the King's Bench in Westminster Hall, right? But that wasn't a matter cognisable only by Parliament, right? But, they used to have hearings in Westminster Hall, or people used to prosecute them. Now, what you'll find is that, in that Harlow Baker case and in other cases similar to that in those parliamentary journals, right, what you'll find is certain people were bringing prosecutions, okay? They were bringing prosecutions against either members of the House or against other people for matters that might have been under the jurisdiction of Parliament. And then what would happen is that they get called into Parliament and said, have you brought this prosecution against someone in the courts? And they'd say, yeah. Then they said, well, you'll have to discontinue it, or, we're going to fuck you, right? And or they might punish them anyway, because that was a breach of privilege, right? And that is essentially that someone brought proceedings in a court out of Parliament when it was privileged, right? That was an illegal prosecution, right? Even if it was in Westminster Hall. But if someone had petitioned the House of Commons that they wanted legal action against someone for something or whatever, and then the House had voted it through, and then the Speaker go to the bar, that impeachment process, and then they could hear it in Westminster Hall because Parliament had decided there was going to be in Westminster Hall, right? So this is an intrinsic part of it. But what they're trying to sell us in here is that it's just proceedings in Parliament, right? But it isn't. It says causes, matters and causes. So a matter is not a proceeding. A matter is a subject matter, right? Proceedings refer to processes, right? If you word it, right, as proceedings in Parliament, that's like a messy civil process, but you're trying to make it sound like that it's only a part of the process, and maybe the part that's takes place inside Parliament, right? So you're trying to frame things by processes and procedures, right? Proceedings in Parliament. But something before Parliament is in order to Parliament. Before means in order to, right? So like proceedings in the Crown Court include, proceedings in the Magistrates Court. It's not just when you turn up there, right? Proceedings in the Magistrates Court is when the police go around to someone's house to get the evidence as well, right? That's proceedings in the Magistrates Court. And by this proceedings in Parliament, they're trying to make out that it does not include other messing in processes. Well, the police aren't messing in civil processes. The police are criminal proceedings, right? But you can have the equivalent in civil is, anything that you need to do, right? And when you use the wording of illegal under Article 9, illegal prosecutions, it says matters and causes, right? Matters and causes. Now, when people are going out protesting, they're protesting a cause, right? And either the cause is to Parliament or it's not. If you go to a football stadium and if there's a football match on and if there's an incident and if everyone is taken off there by the police, right, and then all of the football fans have a little protest that they want to get back onto the stadium, right? That is not a matter or cause recognisable only in Parliament. But if you are collecting signatures against immigration and canvassing it, advertising it, letting people know about it, then that is a cause to the Parliament of England because you're wanting them to stop immigration, right? And that is the issue that we've got at the moment with the Public Order Act, and it's the interpretation of it, and the Riot Act previously. You've got it's not a private. They're not private offences, private crimes, private matters. Like the example with the stadium, right? But when you're collecting signatures and advertising it, you're acting on behalf of a public cause or body, right? So this is the important issue with the wording on it here. And when you use the words matters and causes, you're actually not talking about proceedings or processes. You're not talking about a messy civil process, and you're not talking about proceedings. And what I mean to say is you're not focusing on the process and proceedings. The matter and cause is actually the subject, right? So the matter and cause, if you're in a class with school, right, and you say to the kids, right, if you're a teacher in school and you say, right, give me a matter, shout out any matter, and they might say, one of the kids might shout out, what is the matter? What is the matter today? Whether or not we should be allowed outside the building at break time. That is a matter, right? So if a teacher stands in front of a class and he goes, "What is what is the matter?" And they say, "Well, the issue. You could say issue, right? Whether we can go outside the building at dinner time." Right? You can't go outside if the fucking gates are locked, right? Or if someone falls over in the classroom, you say, "What's the matter? What's the matter?" "Oh, I've hurt my hand," right? That's the matter. An injury, right? An injury. Yes, an injury, And then what happened with the injury? Oh, well, John Smith pushed me over, right? Oh, well, we'll have to ask him why he did that, right? Have you got, then someone might have a grievance. Smith might have had a grievance with the person who pushed him over. So these are all matters and causes, right? So it's by the issue. And I guess they used to have a newspaper called The Big Issue, right? What is the issue, right? The Big Issue, can you remember that? People used to go around town centres and used to have the Big Issue seller, right? The issue, what is the issue? What is the matter? So that's subjective, right? Well, it's what is the subject matter? But I mean, obviously, there is an objective aspect to it because it concerns a real existing thing, right? Like, pollution. Pollution is a physical existing thing. But in order to talk about pollution, right, you have to raise the matter. You have to raise the subject. So it's actually the contextual, subjective pursuit and discussion of it, right? Matters and causes. And the cause is usually the thing that why do they call it a cause? Because something caused it, right? So like in the classroom, when I said, Johnson pushed me over, he caused me to fall, right? But what caused him to do that is that, something might pissed him off, right? So these facts and circumstances, right? I would say, facts, circumstances, so it's not actually to refer to the Article 9 as a procedural reference, in the wording of the article, I do not believe it is a procedural reference because it says that it's matters and causes. Matters and causes are subjective references. They are contextual references. So it's, what's the problem, right? What's the big issue? What's the problem, right? Not what are the processes and proceedings of which we are going to act by. Because that is like Mesne civil process, okay? Mesne civil process is the proceedings, like proceedings in Parliament, but Mesne civil process is not always inside Parliament, it's in order to Parliament, right? Before Parliament, in order to it, like, the police, criminal proceedings, criminal procedure is in order to before a magistrate's court, right? To be before a magistrate's court. It's not everything inside it only. Because how do you execute the fucking warrant, right? You don't execute it in the building. You have to go outside the building to fucking execute it, right? So they're trying to lie about the full extent of proceedings and procedures, which is devilishly dastardly, really. And I think this is Keir Starmer's problem, But he's just another, victim of this misinformation cult, this bullshit merchant cult that, actually lie in the parliamentary documents when, everything needs to be corrected. According to Andrew Bridgen, you have to go in there and correct it. But we'll have a hard time now because half of them have deceased, So a lot of this needs correcting and putting right. So it's always in relation to the subject. Now, this is the thing when you go back to Strode's Act, when it says anything concerning Parliament, right? So matters and causes concerning Parliament, right? So, but Parliament is there to bring causes matters and causes to. That's what it's for, to bring matters and causes to the Parliament. So they can, make resolutions, acts and laws and things like that, or other processes and procedures that cannot be or could not be resolved in the courts, or they might be issues within Parliament that cannot be resolved in the courts because they can only be resolved in Parliament. So you have to raise them with the Parliament, right? So that's just a briefing, but there's quite a lot to read here. I mean, there's a tiny little scrolling pixel on the right-hand side, a grey one, and I've just got the highlighted blue part level with it now. And that's how far the little tiny scroll bar's got to go down when you finish reading all this. And I haven't even got into it properly yet. But I know that this 1980 resolution, a lot of people have been having their matters or issues talked about in the courts when actually it's privileged, and that proves that they've actually got a parliamentary cause and matter, which is what happened with a lot of the Extinction Rebellion cases. So not all of them have a petition, but some of them have got websites which are calling for the government to do something or not. And none of, you see, that needs to be challenged in court. You need to go into court and put a case for that. Does having a website which is asking the government to do something, is that a matter or cause decidable and debatable only in Parliament, right? If they're asking Parliament to do it and only Parliament can do it, do you have to actually collect loads of signatures? And in fact, what they said in the 1832 Public Petitions Committee report is that people didn't used to sign petitions under the observation of due process of law 1386 because the community came together, and usually like a clerk or somebody would write it down and say that the community have got this issue, and then send it into Parliament. So it was like a written piece on behalf, a representation on behalf of the community, but they didn't all actually signed it. And it wasn't until the king started challenging them and saying, no, we don't think that the community really does want this or that. The community would like the king to give them some more lands or let them hunt on his grounds in Norfolk or Huntingdon or something, right? And the king would say, no, I don't think that the public do want me to do that, right? So, in order to prove that the whole community did actually support that, then they started collecting all the signatures. So then when they sent it into Parliament or into the king, then the king couldn't say, well, I don't believe you, or I don't think the community want that. But when the whole community's signatures were on there to show that they do, then he can't say that they don't, right? So it was it's like evidence to prove the claim. Because on some of the claims, it wasn't being believed, right? So it was actually for evidence purpose to prove that the claim was in fact supported by X number of people. Now, you might not have needed, if it's only a family making a claim, you don't need the whole village to do it. If it's wanting to get a law changed for the whole country, then you might have to substantiate that, a large amount of people want that law made or changed, right? Unless people oppose it. And this is when you're getting through to companies and businesses who are getting privately sponsored bills, private acts for companies, do all the shipping companies want the law changed? Then, you don't need to get the whole country to sign it to prove that the shipping companies want it changed, but the people might not want that law changed, right? It might affect them, just to say that every single, every developer wants to build a McDonald's, they all sign it. All the developers have signed it, but, do the people want McDonald's in their village or not? This is the thing. Stuff like that. And actually, we are supposed to be able to petition Parliament about building matters. really, building and planning matters was heard in the assizes, right? Unless you had a corporation in a town, which had a mayor in it, an alderman, and then they would deal with it like the William Penn trial when you had like the mayor of London and the alderman was a criminal case, right? Otherwise, you had the assizes coming round and you could appeal it and stuff like that, just like any other case. But now we've been misled because. They're trying to make out that you can't appeal council decisions, which is absolute tosh. They actually had a committee, a committee of 3, which you could appeal to, but there was a process where you could have it go to Parliament instead, which was almost kind of like, there was a guy, I've got a video of this man, and he apparently was waiting in the court to be heard, and he said that he wanted it heard by the Queen's Bench instead of that court. And he actually apparently did get it put to the Queen's, and then they didn't pursue it with him anymore because the Crown Prosecution Service couldn't be bothered following it to the King's Bench, because, if you get, the CPS can't challenge a jury trial verdict, apparently, but like with Angela Ditchfield, when she got acquitted by the Magistrates' Court, Max Hill went after her at the High Court because she hadn't actually been acquitted by a jury. When that was Extinction Rebellion, that was like, she's supposed to be using the Town and Country Planning Act 2007 control of advertisements, right? And obscene publications and all that type of stuff. Extinction Rebellion was a parliamentary cause, right? And Max Hill went and prosecuted her in the High Court. What that other gentleman did, that guy, and I've got the video somewhere. I've got that video on my channel. Actually, I've uploaded that video. I've got a copy of it on the channel, right? I could put the link underneath this video, and he's kind of like, in a way, he's kind of like telling people that he just went into the court and did this. He said he wanted his case heard at the Queen's Bench, right? Which apparently, supposedly, you could have it heard alternatively at a higher court, right? And that's what I'm saying, that you effectively are meant to be able to do with like building things for the council, right? But and then we got an argument with the e-petitions team that the 2010 order said that. The 2010 order effectively said that local planning and licensing matters aren't to be regarded as local matters. So therefore, when you petition in Parliament, they're not to consider it as a local matter. So how can they say, we can't have it because it's a local matter? It's not to be regarded as a local matter, right? So there's a lot of planning and licensing issues around this country that people were trying to petition Parliament over, and we're getting blocked. And people are in a lot of dilemmas. We've got this Colchester Council Watch channel, which are going into local councils with lots of people's problems and issues, and trying to reveal what's happening in these local councils. A lot of these McDonald's, Subways, things like that, which got built, or factories that got built, huge, massive buildings, or these developments that people don't want in their area, shouldn't have been allowed, or they were allowed to. There was in law meant to be a route to take to do something about it. And all that we ended up being given was this judicial review, which is only actually meant to criticise the processes and procedures, like the law of it, right? Not the decision. And it costs a lot of money to do these judicial reviews. And in fact, that's actually what Graham Moore has just been in the High Court yesterday, the 16th, because that election petition which took place at Runcorn Helsby, the Royal Mail group or whoever appealed it, but you cannot challenge an election petition. It's not actually an appeal. Instead, you can have it reviewed or looked at, it's more like a judicial review type of thing, and the powers were meant to be supposedly limited, but it's not actually in a proper appeal. It's more like a judicial review, and that's what the Bill of Exemption existed for in the Statute of Westminster The second, the Bill of Exemption was to challenge the judge, you know, on law that he's interpreting the law wrong, or on a point of law, or on a right, you know, or a process not being followed, or something like that, right? Which is the Bill of Exemption and like a writ of error, right? You had the writ of error as well. So what that election petition challenge was in the High Court yesterday was more like it's more like a writ of error than an appeal. And what they're doing with the local council authority decisions is they're making us only be allowed to do these kind of writ of error type things, which equate to a judicial review. In my opinion, it's a similar or the same thing. You're not actually appealing the decision, and they're trying to make out that you can't appeal the decision, right? Which I don't believe that there is no, you know, there's like, you know, no remedy at all. There is a remedy, because you're meant to be actually able to have it heard in Parliament instead, or you can appeal them. Like the assizes could be appealed to the High Court, right? And when the corporations took over, just because you've been taken over by a corporation and a mayor with aldermen, right? Why do you not have the right to appeal anymore, like you had when you have the assizes hearing the same matter? Because you didn't have a town, right? If you don't have a town, then so what? You know, it's you're still like, if someone's wanting to build 2 cottages, right? And they hit it at the assizes, surely you can appeal it, right? Because that's how the courts work, right? And I think that when people don't see the local council as a court, but yet when you get interested in the Lord Mayor of London and the Court of Aldermen and then the Court of Common Council, what is that? Well, that is like the full council. Or you just have the mayor and the alderman, right? He's court. And then you go like William Prynne. What the fuck's William Prynne doing in there? I mean, not William Prynne, William Penn, right? William Penn and William Mead, right? What the fuck are William Penn and William Mead doing in the court with the aldermen in London with a criminal trial? And oh, there's a jury. Look, this is a strange situation. Look. It's the Lord Mayor of London with the aldermen, right? You know, sandwich short of a picnic, right? Where's the rest of the full Common Council assembled? Oh, we don't need them all because we're just having a little criminal procedure here with William Penn and William Mead, and then there's a jury there as well. We seem to have lost the jury. That's funny. We're getting some cottages built, and I won't imagine them making a decision because these crooked Labour and Tory aldermen and councillors are bent as a doorknob. You know, this is the thing. So, but you see, that's there's a shift there, because this is the standing orders of the Court of the Aldermen, right? The standing orders of the Court of the Common Council are that only a councillor can present a petition on behalf of his, you know, local area. So it's like, you know, this is when you've got like, you know, all these different councillors for the City of London. You know, if he's your councillor, you give him a petition and he hands it into the Court of Common Council, right? But the Court of Aldermen is different. It's like a civil and criminal court, and they've got a privileges committee, right? Because, you know, William Penn and William Mead might have actually had consent to petition Parliament when they were doing the 1661 Tumultuous Petitioning Act, and they might have been privileged, and the 20 people who were in the street might have been privileged, and therefore you got the privileges committee, and the petition about your privileges. In fact, you need to petition for leave of court, don't you, for Parliament, right? That's when you've got this petition of leave of court, which is the whole point of this here, right? So people need to. I actually found it because I was struggling with it and chewing on it for a bit, looking at some old acts of law and trying to figure it out, right? But the City of London model is like that's like I totally got it then. I was like, all right, yeah. So you've got a court of full council, then you've got mayor and alderman, but we don't have, the mayor's only ceremonial now because you've got like the cabinet in the local council, right? You've got like 3 councillors on the cabinet, right? Which is the equivalent of, it's like a mini version of like the Lord Mayor and the alderman, right? But it's just a court. because they've got a corporation, right? But you didn't always have a corporation because some towns and villages didn't have one. They didn't have a charter, right? So, like, all of their building and planning matters had to be heard at the quarter sessions or assizes, but it's just still the king's judges fucking going around on a circuit, right? Or they'll appeal it to High Court, right? This is the thing. Or King's Bench even, or whatever, or, it's Parliament. This is the thing. So, it's sussing out. We are being sort of misled and conned and tricked in a way, mainly by these main political parties. And then now when you get these metropolitan councils and these mod after, sort of like 1970, when they get rid of all the assizes as well, it's like, what are you looking at? Well, you've got all these different councils because you've got a big area, right? You've got all these different, like our area, Kirklees, you've got like 3 councils per area, and then you've got a big area stretching out, and then they're all, when they're all there, but they're just there to hear local matters and issues that need to have orders put through and made, but they don't hear criminal matters because that's been put to, really, the magistrates' court is like a committee of 3 justices, right? Or a district judge, or the county court, right? And the local council don't hear civil matters. You see, but they deal with civil matters because they have fines. Like the council fines someone, but they don't. They issue the fine, but if for enforcement, right? They don't deal with the enforcement of the fine because they send it to the magistrates' court because they deal with the matter, and then they've got loads of new laws in that people on the people on the council can't be certain magistrates or the stuff like that, right? Between it, but when it was like the model of what they've got with the City of London, it's different. It makes more sense. But that William Penn trial in the Court of Common Council is really important because that's to do with this petition of leave of court. I've got to finish reading this now anyway, but I just wanted to say that.